Be ready for the dictation. Start. These appeals have been filed assailing the final orders of the High Court of Himachal Pradesh dated 11th December 2008 and 6th May 2009, whereby the Veers of the Himachal Pradesh Passengers and Goods Taxation Act, 1955 as amended from time to time, particularly by the Himachal Pradesh Passengers and Goods Amendment and Validation Act, 1997 has been upheld and the writ petitions filed by the appellants herein, i.e. Civil Writ Petition number 725 of 1998 and 79 of 2007, have been dismissed. The controversy in these cases revolves around the question whether, by enacting the Amendment and Validation Act of 1997, the Himachal Pradesh State Legislature has validly removed the basis of the judgment of the Division Bench of the High Court dated 27 March 1997. In the said judgment, the Act of 1955 had been held not to include within its scope the activity of the appellants in providing gratis transport facilities for their employees and their children, as the charging provision contained therein, namely, Section 3(1), and the explanation thereto were couched in very ambiguous terms. These appeals also call for consideration of ancillary arguments in the matter such as legislative competence of the Himachal Pradesh Legislative Assembly to enact the Act of 1955 and the Amendment and Validation Act of 1997, which are stated to be enacted on the strength of Article 246. Read with entry 56 of List 2 of the 7th Schedule of the Constitution of India. Further, these appeals also call for interpretation of certain provisions of the Act of 1955, as amended by the Amendment and Validation Act of 1997, so as to determine whether the activity of the appellants would be a taxable activity under Section 3 of the Amendment and Validation Act of 1997. Since the controversy involved in these appeals is identical, the appeals are being disposed of by way of this common judgment. For the sake of convenience, the facts of the lead matter, i.e., Civil Appeal number 3498 of 2009 shall be narrated as under. The facts in a nutshell are that the Act of 1955 was enacted by the Himachal Pradesh Legislative Assembly with a view to levy tax on passengers and goods carried by road in certain motor vehicles in the state of Himachal Pradesh. The said Act received presidential assent on 25 November 1955. The appellant, NHPC Limited, is engaged in the generation of electricity and has various projects in the state of Himachal Pradesh. Many project sites are situated at different locations in the interiors of Himachal Pradesh. These work sites are not properly serviced by any public transport system or regular taxis. The residential colonies of the staff employed at the various project sites are located at far-off distances from the project sites. Therefore, as a welfare measure, the appellant, NHPC Limited provides transport facilities to its employees in order to enable them to reach their respective work sites from their residential colonies and for their children to travel to and from their schools comfortably. It is to be clarified at this juncture that the transport facilities were being provided free of cost for the exclusive use of the employees of the appellant, and their children and members of the public were not permitted to use the said transport facilities.